All right, good morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court. Today, I will let you know if I've determined probable cause, and then we will also talk about release conditions. Please note that today is not your trial date, and so everything you say in this courtroom is being recorded and can be used against you. So my advice to you is before you say anything on the record, please speak with your attorney, consult with your attorney before doing so. If you are represented by the Public Defender's Office, there is an attorney from the Public Defender's Office who is in the courtroom with me, as well as there's an attorney over at the main jail. For those of you who have private counsel, those attorneys do come to the courtroom and are able to speak on your behalf. If your attorney is not here, you can let me know, and we will see how we can facilitate you in contacting your attorney. Please do not tell me that you have an attorney if you or your family have not retained them for this arrest. Just because an attorney represented you in the past does not necessarily mean that they're representing you today on this case. And I have almost every other day somebody tell me, yes, I have this attorney, and I make a phone call, and for that attorney to tell me, no, I have not been retained for this case. So just so you understand, that unless you or your family have retained them in the last 24 hours, or you knew ahead of time, they're probably not representing you. Also in the courtroom, I have with me the state attorney's office, an attorney representing the state attorney's office. I have a representative from confinement status, pretrial services, and I also have representatives from the clerk of courts. All these persons are here today to facilitate these proceedings and are able to give any additional information if needed in making a determination on each of your cases. And so I will call each person individually, and then we'll address your situation individually. Some of you on misdemeanor cases only. I cannot make any changes, take any pleas on felony matters. I cannot make any changes on no bond holds on violation of probation matters. But for some of you with misdemeanor cases, usually the trespassing and those kinds of cases, if there is an offer, you may be able to resolve those cases today, okay? Mr. Reedy, has anyone from the jail, is the jail asked for anyone to be called out of turn?
Yes, Your Honor, there are three.
Okay,
On page 23 of the court's docket, Mr. Martins.
okay.
On page 16 of the court's docket, Mr. Wiggins. And on page
Hold
24,
on, hold on, Mr. Romero.
page 16, Mr. Wiggins.
Okay,
Page 24, Mr. Walker.
Walker on page 22. Is there another Walker? What's the first name? Is it Joshua Walker? On page
I believe
24?
it is Joshua Walker.
Okay. And while we're finding those paperwork, Mr. Romero, Corey Letarte on page 22, he has a private attorney here. I don't know how far the jail, they don't bring everyone
Page
in.
18,
So-
heard, and they're gonna go ahead and get it.
Okay, so once he's in the room, Mr. Stark will be able to ask him. What page, up to what page do you have persons?
18.
Okay,
18.
okay,
He's in jail.
okay. All right, Michael Martin. Mr. Martin was on which page?
23, Judge.
Is he represented by the Public Defender's Office?
Yes, Judge, he signed up with the Public Defender's Office.
Okay. All right, Mr. Martin, you're before the court this morning. Charge 1 is attempted felony murder, and number 2 is throwing a missile into a dwelling or vehicle. The court does find probable cause as to those 2 charges, and I will hear from the parties.
And I'm sorry, Your Honor, I apologize. What did you say the charge on count 1 was?
Well, I read it as presented, attempted, well, on the PC, it does say attempted felony murder, but I know on the
Yeah.
arrest form, it does say attempted murder, second degree.
Yeah, okay, and it was, I confirmed it was filed as an attempted second-degree murder.
Okay,
Your Honor, I provided the court and counsel with a supplemental report that goes, adds additional details that were not contained in the affidavit for the order to take Mr. Martin into custody. Your Honor, I have great concern, not only for the victim's safety, but for the safety of the community. You can see the allegations are that Mr. Martin shot the victim in the face. It would appear from the allegations, the victim is lucky to be alive. It has, as a result of the shooting, it has caused permanent blindness in the victim. I would also note the driver of the vehicle where the shooting occurred, in an understandably panicked state to get away from the scene after a shot was fired and one of the passengers was shot, lost control of his vehicle and got into a significant crash that caused significant injuries for the driver. I think that's something the court should take into consideration also. I would note as far as juvenile history, it would appear that it looks like Mr. Martin is still on juvenile probation for 7 counts of grand theft auto, 1 count of grand theft. He also, Your Honor, the state is going to be requesting on count 1 a $250,000 bond, a $25,000 bond on count 2, pretrial release with a GPS monitor, level 1, and no victim contact, no possession of any firearms or weapons, ammunition. And I apologize, Your Honor, it also mentions in the supplemental report that Mr. Martin confessed to the shooting, and there is no evidence to indicate that he was provoked or acting in self-defense.
okay.
Judge, Mr. Martin doesn't work. He's 16 years old. I believe he's going to be entering 9th grade. He lives with his mother, and that's where he'll be residing, Judge. His mother, my understanding, is on disability. So I'm asking you to take that into consideration as far as the financial bond, as far as the specifications at this time, or we wouldn't be objecting as far as having Mr. Martin supervised. But financially, he's not going to be able to afford what the state has asked for.
All right. These are always very difficult reports to read, take into consideration Mr. Martin's age, but also take into consideration the situation that is before the court this morning. And so at this time, the court does find probable cause. I am going to impose a $250,000 bond on count 1. $25,000 on count 2. He will be on level 1 GPS. No possession of any weapons or firearms. No victim contact. Mr. Martin, do you understand those conditions?
Yes.
Okay. Okay, thank you. Dustin Wiggins.
He's approaching, Judge. He's coming up.
I got it. Yeah. No.
All right, Mr. Wiggins, you are before the court this morning. Charge 1 is DUI, alcohol or drugs. Number 2 is DUI with a breath greater than .15. 3 and 4 are felony violation of probations with no bond holds. And number 5 through 22 are out-of-county felony holds, and those are all out of Palm Beach County, and those have bonds attached to them. The court does find probable cause. And Mr. Wiggins also does have court on the felony matters tomorrow before his division judge. And the bonds on 1 and 2 will remain $500 and $1,000. Okay?
Yes, Judge.
Joshua Walker.
He's approaching Judge here at Maine. Hold on one moment, Judge. He's coming up, Judge.
Okay. All right, Mr. Walker is before the court on 1 count. Mr. Walker, you're before the court on 1 count of criminal mischief. Count 2 is disorderly conduct, and the court does find probable cause. Does anyone wish to be heard?
No, Judge.
All right, so Mr. Walker has a bond of $500. Okay? Yes?
Your Honor,
Yes.
Your Honor, I'm going to be requesting a $2,500 bond.
On which case are we talking about now?
This is on Joshua Walker, Your Honor?
Yeah,
Yeah, okay. On count 1. Order no victim contact, no return. Reason being, first off, I would note just the amount of damage. It was estimated by the witnesses' business owners that a total amount of damage of $18,000 to the business. I would note he has an active injunction order of protection out of the state of Virginia. One moment. Looks like he has a pending grand theft of a firearm out of the state of Virginia. He was arrested May 27th of this year. Pending shoplifting from a May 20.
is there a warrant for him out of Virginia?
There's not a warrant, but
Okay.
at least there's nothing entered as of yet.
Okay,
Misdemeanor firearm offense from May 27th. And nothing further, Judge.
okay.
Judge, and speaking of Mr. Walker, he's not going to be able to come up with that bond amount. He's 24 years old. He promises he will come back to court, Judge, and account for these allegations. He's going to be requesting if the court would consider releasing him on pretrial release.
All right, I'm gonna
And
deny.
also, if he's not in jail, he can start saving up some money to make restitution, which he's not going to be able to do if he is in custody.
All right, I'm gonna deny pretrial release. The bond is $500, no victim contact and no return. Right.
Your Honor, could you call Michael Millsap on page 15? He's at the North Broward Detention Center.
Okay,
And Judge, whenever you're ready after this gentleman, you want me to let you know when that other gentleman arrived that was here at Maine that had a private? He's here.
okay, thank you.
Ask her to step.
Michael Millsap, Mr. Millsap, on page 15. Mr. Millsap is charged with aggravated assault with a deadly weapon without intent to kill. The court does find probable cause. Who do we have?
This is the alleged victim in the case, Ms. Zwick.
Okay. Ma'am, is there something you wish to say to the court this morning?
I was terrible.
Oh,
Michael, don't say anything right now, okay? Just
Okay.
listen.
all right, I know, but if you can speak through the microphone.
I was terrorized for 7 years, almost 8 years, and I was stupid enough to let him go. This time he came at me with a butcher knife, told me he was gonna kill me, and he couldn't wait to do it. You know, my daughter and my son-in-law were with me. He also threatened them, and I just can't do it anymore. So what I would like to ask you is if I could have an order of protection until I need a safe place to live Women in Distress will help me come up with funding to move out. I do work all the time, but I just don't make enough for the down payment and all that to get into a safe place. So if you could do an order of protection, just until Women in Distress can help me get out of his life, get out of his home, get away from him and never have to see him again. That would be wonderful. And when I leave here, I'm gonna get a restraining order. And, it was just pure evil that came at me. He knows that he has mental problems. He hurt me years ago. I didn't, and then cut himself to make it look like he was trying to commit suicide.
Okay.
So that he had to go get mental health. Nothing ever happens to him.
Ma'am, just so you understand, this is first appearance court, and here, today, I made that announcement in the beginning that my purpose here today is to determine probable cause and to set a bond. From here, this case is going to be assigned to a division judge. And I know that you are in touch with the attorneys from the state attorney's office. They'll be able to let you know if and when you have to come back to court to make any further requests. And I'm sure that they'll speak with you and let you know what you need to do. All right, but for today,
Honey, I'm sorry.
sir,
Michael, don't, this is not the time to start confessing, man. Don't
So-
say anything.
As I just said, I was sorry that
So,
all this
so
happened
for
to me.
Mr. Millsap, everything that you say here today can and will be used against you, okay? So for today, ma'am, I am,
I'm not gonna take that back.
well, you need, okay, but I need you to stop talking so that I can conduct this hearing, okay? So for this, for today's purpose, I am going to enter a no contact order. That means that there should be no phone calls, no text message, no social media, no third-party contact. And if you violate that order, you could be before the court again. And anything further, ma'am, you need to speak with the state attorney's
And Your
office.
Honor, and I will also explain to Ms. Wick that Your Honor's order just applies to the criminal case, but as far as other options, our office can assist her in seeking a civil injunction. Also, there's also services available to victims that we can provide her information on. Your Honor, as far as today's purposes, based on the allegations and some of the information that has been provided by the victim, Your Honor, and I would also note Mr. Melsop's criminal history. As far as Broward, a 2008 possession of cocaine, 2000 felony DUI with a violation of probation. He was sentenced to 38 months in Florida State Prison. 1993 burglary of a dwelling. He was sentenced to 9 years state prison. 1984 false imprisonment, aggravated battery with a deadly weapon. He violated probation, 18 months state prison. There's also been additional drug priors. I'd also note, Your Honor, that Deputy Curran noted at a minimum that she checked off the alcohol influence box. Your Honor, I'm going to be requesting a $10,000 bond, no victim contact, pretrial release of the GPS monitor, should he post a bond, and no possession of any firearms, weapons, or ammunition. Nothing further, Judge.
Yeah, I can pretty well tell you, Judge, he's not going to be able to afford a $10,000 bond. He's been living here since 1959. He's retired, doesn't have a lot of money saved up. He does have some physical health issues that really do concern me quite a bit. But he's not going to be able to make a $10,000 bond. I don't think there's any problem, based on my conversation with Mr. Millsap, that he stays away from Ms. Wick. And what the state attorney said is true. This court doesn't have the ability to issue no contact orders except for to him. And he will have no contact with her if he is released. But I don't think he's going to be able to afford a monetary bond at all, Judge.
All
So
right,
I'd be asking for pretrial release.
all right, at this time, the court finding probable cause, and based on the information that has been provided to the court this morning, I am going to impose a $7,500 bond. And if Mr. Melsop posts his bond, he will also be on a level 2 pretrial supervision. That includes, that's an ankle monitor. Mr. Melsop, no weapons or firearms. until any further order of the court and no victim contact. Do you understand that, sir?
Yes.
Okay.
So, on the first, could you get that 750?
I really don't think that's going to be happening, Michael. I think that we're going to send somebody up to see you as soon as we can, okay?
You very well.
All right, let's address Corey Letarte on page 22.
Jim Stark on behalf of Corey Litar.
Good morning, Mr. Stark.
Judge, we stipulate that the affidavit reveals there's probable cause.
Okay,
The state and I are prepared to agree that with respect to the aggravated assault count, a $2,500 bond would be sufficient. For your honor's information, Corey's been a resident of the state of Florida for most of his life. He has no criminal history. This incident occurred, is alleged to have occurred back in November. These kids had a relationship at one time, so there's been plenty of opportunity for hostilities to continue. They have not. Corey, as soon as we found out there was a warrant, self-surrendered yesterday, so the bond is sufficient. And we would ask you to just OR on the other two counts.
My intent is that the bonds are gonna stay on those, and there's only 2,500.
What's that? Yeah.
Your Honor, the agreement, and it maybe is a miscommunication between Mr. Stark and myself. I did agree to 2,500 on count one. It was with my intent, keeping the bonds on the other two counts in place. I was originally, in full candor, I was seeking a higher bond originally. I spoke with Mr. Stark. I do acknowledge that this occurred in late last year. He has no adult history, and that's why I agreed to a $2,500 bond. That being said, I do have some concerns based on, and I won't go into detail, Your Honor's familiar with the allegations, but I do have some concerns based on these allegations, noting that there was also a witness that corroborated the victim's version of events.
all right,
It's his father.
Good morning,
Corey
sir.
works with his father, so he's with him every single day.
okay. The court does find probable cause, and I will impose the $2,500 on count one as the parties agreed to. The other standard bonds will also remain in place, $1,000, and then on the criminal mischief, I'll ROR on that one, okay?
Okay.
And no victim contact?
She's been texting him religiously for the past.
Just so he knows that this order relates to you, Mr. Letard, and you cannot contact the victim in this case, no phone calls, no text messages, no social media, so the onus is on you. So your attorney's saying that he'll explain it to you, but you cannot have any contact, okay?
Certainly, he can, maybe ask his father if he doesn't, to reach out and please stop contacting him.
Okay?
Okay.
Good
Thank you,
luck.
Judge.
Take care.
Nice seeing you.
Same here.
Our Spanish interpreter is present, Your Honor.
Yes, we are very busy this morning. Yep. Who needs the Spanish interpreter?
Yeah, Judge, that gentleman would be on page, page 7, Mr. Luis Urbano.
See what things are.
Luis Urbano? He's approaching, Judge.
Okay, hold on.
Sure.
Okay, Luis Rubano.
Luis Robina.
Urbina, thank you. Mr. Urbina, you're before the court this morning. Charge 1 is touch or strike battery, domestic violence.
Señor Luis Robina comparece hoy por una acusación de tocar o golpear, es agresión y es por causa de violencia doméstica.
And number 2 is obstructing or depriving means of communication.
El segundo cargo es obstruir o no permitir que una persona use un instrumento de comunicación.
The court does find probable cause,
La Corte decide que existe motivo fundado.
and I will hear from the parties as to bond.
Vamos a hablar con las partes sobre la fianza.
Your Honor, Mr. Robena has no criminal history.
Señoría, el señor Robaina no tiene antecedentes penales.
That being said, I'm going to be requesting a $7,500 bond on count one.
No obstante, voy a pedir una fianza de 7,500 para el primer cargo.
A $2,500 bond on two.
Para el segundo cargo, 2,500.
An order of no victim contact.
Y le va a quedar prohibido tener contacto con la víctima.
This is based on the level of violence.
Basamos esto sobre el nivel de violencia demostrado.
Noting that the defendant punched and kicked the victim multiple times.
Y debemos tener en cuenta que se alega que el acusado golpeó y también pateó a la supuesta víctima varias veces.
Kicking the victim while she was on the floor.
Pateó a la víctima mientras estaba tirada en el piso.
The arresting officer documents that the victim suffered massive bruising on her face.
Y el policía que hizo el arresto documentó que la víctima tenía muchos moretones en su cara,
On her stomach, arms, feet, and legs.
también en el estómago, en sus pies y en sus piernas.
And this also occurred in the presence of at least one of their two minor children.
Y parece que mientras ocurrió esto estaban presentes por lo menos uno de las criaturas menores de edad de esta pareja.
Nothing further.
No, del Estado nada más.
Judge, in speaking to Mr. Rubino, we were going to be asking for a $2,500 bond on count one and a $1,000 bond on count two.
Señoría, después de hablar con el señor Robaina, vamos a pedir que la fianza para el primer cargo que sea de 2,500 y para el segundo cargo 1,000.
Judge, he's been residing in South Florida now for about 15 years. He's 52 years old.
Señoría, él está viviendo en el sur de la Florida 15 años, tiene 52 años.
Judge, my understanding at this time he is not working.
Y, señoría, tengo entendido que en este momento el señor no está trabajando.
Doesn't sound
The place where him and the alleged victim reside is actually his home.
El lugar donde vive él y la supuesta víctima, de hecho, es la casa de este caballero.
And right now he advised me he's going through a financial crisis in which he hasn't paid the mortgage in quite some time, so he believes he's going to be under foreclosure proceedings.
Y porque tiene una crisis económica en este momento, no ha podido pagar la hipoteca por muchos meses y teme que muy pronto lo van a desalojar de la casa.
Now, most importantly, as you heard, Judge, he has no prior criminal contact with the system.
También es muy importante lo que se dijo anteriormente, él no tiene ningún tipo de antecedente penal.
He has other strong ties to the community. He does have family that live here in South Florida.
Tiene vínculos muy concretos con la comunidad, tiene muchos parientes que viven aquí en el sur de la Florida.
He did give me his phone number of his brother, who I intend to call after court to see if he can help him with his monetary bond. But then that is why the defense is requesting a total of $3,500 bond on Mr. Rubino's behalf.
Y también me ha dado un número telefónico del hermano, voy a intentar comunicarme con él después de estos procedimientos para pedir que lo ayude a pagar la fianza. Por eso, señoría, esos $3,500 que pedimos de fianza, esa es la fianza que pedimos para el señor Robaina.
All right, at this time, the court's going to impose $2,500 on both counts.
Muy
No.
bien, en este momento la Corte decide que la fianza para cada cargo va a ser 2,500
No victim contact until further order of the court.
y le queda prohibido tener contacto con la víctima hasta que tenga una indicación a lo contrario de la Corte.
Okay?
Thank you, Judge.
All right. Is there anyone else who needs a Spanish interpreter?
¿Alguien más que necesite la ayuda de la intérprete?
No one here at Maine, Judge. I don't know about the other facilities.
Not that
Anywhere?
they've advised me,
Okay,
but I know they're listening, and if they need one, they'll let us know.
okay. Well, hearing nothing at this time, thank you very much.
Great to see you. Have a great day, Your Honor.
Always, thank you.
Thank you.
All right, on page 9, Eric Glasgow.
Glasgow.
These are Mr. Shate's cases. All right, Mr. Glasgow, you're before the court on a misdemeanor capious matter, and
This is actually a City of Fort Lauderdale case. It says Oakland Park on the docket, but the City of Fort
the
Lauderdale.
city of Fort Lauderdale.
Correct.
Can he go to community court? What does he want to do?
Judge, you'd like to resolve the matter if you could.
All right,
I'm not sure if he's eligible for.
the charge is alcoholic beverage. Okay. Mr. Glasgow, what do you wish to do today, sir?
I'd like to resolve.
All right, your sentence will be a withhold adjudication and court costs. Do you wish to accept that?
Yes, ma'am.
Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You okay? You can put your hand down. And do you understand everything that is being said to you today, sir?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you need any more time to speak with your attorney?
No.
You understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Glasgow? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is withhold adjudication court costs. You'll have 6 months to pay your court costs. Good luck.
Thank you, ma'am.
Trung Fan. So no capious. Mr. Fan, you're before the court today on a misdemeanor capious. It looks like you did not show up for your arraignment last September. You were supposed to be in court and didn't go to court, so. No, that's okay, because you're here today. What do you wish to do with your case, sir? Do you wish to resolve the case today?
I don't know what it is.
Sir, do you understand English?
Yeah. Because I gotta jump out there, I have to go work.
Okay, well, you and I have to be able to communicate so that I know that you understand what's going on. So, Mr. Shea, what's the offer from
Judge,
the
it's
city?
time served.
Okay, so the city is offering adjudication and time served. If you accept that plea today, I will sentence you today and you'll be done, you'll be out today if there's nothing else holding you in custody. Do you understand that, sir?
Yes, yes, sir.
Okay,
Yes, ma'am.
so, I'm gonna ask you to raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Fan, do you, understand the offer that, as I explained it to you?
Yes, ma'am.
Is anyone forcing you to accept that offer?
No.
All right, and do you need any more time to speak with your attorney?
No.
Okay, and do you understand, sir, you do have the right to go to trial. You don't have to take a plea today. But if you take a plea today, you're giving up your right to trial. Do you understand that?
Yes.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Fan? Guilty or no contest?
No contact. I don't know where he is. No contact. No contact.
Okay, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served. Good luck. Mark Rowiser, On page 10,
Perfect pronunciation. The toughest part of the job.
you know. Just call out the syllables, that's what they tell me. All right, sir, you're before good morning, you're before the court for a municipal ordinance violation.
Yes.
And the court finds probable cause. What do you want to do today, sir?
Resolve?
Is a time serve
It is,
offer?
Judge, for Pompano Beach, correct?
So the city of Pompano is offering a time served to resolve the case. Do you wish to accept that?
Yes.
All right. Please raise your right hand. You swear or affirm to tell the truth?
Yes, I do.
Okay, you can put your hand down. And do you understand everything that's going on here today, sir?
Yes, I do.
Is anyone forcing you to resolve your case?
No.
And are you under the influence of drugs or alcohol?
No, I'm not.
Do you need any more time to speak with your attorney?
No.
And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, I do, Your Honor.
Have you ever been treated for mental or emotional illness?
No, I have not.
And sir, do you understand that if you are not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, I do.
What plea do you wish to enter?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir.
Thank you very much.
All right, and do we have Jeremiah Sneed in the room?
This is the one.
Yeah.
On page 25, Jeremiah Sneed.
25, yeah.
I've been informed he bonded, Judge?
They're saying he bonded.
No, Calvin, what is this?
I looked at the case numbers and I'm
Talk about being informative.
Is he bonding?
But he said he just bonded.
Confinement, he has bonded? All right. So he's bonded.
That's definitely state.
Right. Okay.
That's county ordinance.
Okay, then all right, good, all right, thanks.
Everything okay? All right, so all right, and then someone is signed in on Diedrich Johnson on page 18. This is just a violation of. Morning. You're here on this case? You signed in on this? All right, Mr. Johnson, you're before the court on a violation of probation matter. This is out of Miami-Dade. It's a Dade County hold and it's a no bond hold. So he's just here for me to let him know, and I guess, I don't know if Dade is coming to pick him up or if he'll be transported to Dade to handle this, because he doesn't have any Broward charges, it's just the Dade charge, okay? All right. You're welcome. Kendra Miranda.
She's here present, Judge, at Maine. She is a present. Come on up, ma'am.
All right, Ms. Miranda, you're before the court. Charge 1 is touch or strike battery domestic. And number 2 is throwing a missile into a dwelling or vehicle, and the court finds probable cause. And I'll hear from the parties as to bond.
Your Honor, state would be requesting a $1,000 bond on 1, a $1,500 bond on count 2, in order of no victim contact.
Does Ms. Miranda have any priors?
I don't see any.
Okay.
Judge, I'm going to be asking for the court to consider an ROR or in the alternative, a $500 bond on count 1, $500 bond on count 2. And this is the reason why, as you heard, she has no prior contact with the criminal justice system. She's a registered voter here in Broward County. She's been here her whole entire life. Right now she is working. She works at a doctor's office. She has 4 children. None of the 4 kids that she supports are of the alleged victim. My understanding, the date of incident, I believe, happened a couple days ago. My understanding is Ms. Miranda was the person that contacted law enforcement She advised me that she was defending herself, and then she contacted law enforcement. Law enforcement was taking too long to basically arrive at the scene, so she then went directly to the Lauderhill Police Department. Now, my understanding, Judge, is when the police arrived, they spoke with her husband, and that's when I believe her husband may have given his own version of what happened. Having said that, Judge, they are going through a divorce. She is slowly moving out, and I believe that's one of the main reasons as far as why the husband gave some of the facts to law enforcement. She is looking forward to contesting these allegations. But Judge, considering as far as her very strong ties to the community, her lack of any criminal priors, that is why we're asking for a straight ROR, or in the alternative, like I said, $500 bond on each count, Judge.
Okay.
Yes.
All right, at this time, I will grant the $500 on each count. No victim contact, ma'am. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes.
Okay?
Her request, Judge, she
Yes.
still has belongings there at the premises she's moving out. Can she go one time with law enforcement to get the rest of her belongings?
One time with law enforcement, yes.
Thank you, Judge.
Felicia Fisher,
Ms. Fisher is a North Broward judge, and she would like to resolve this matter this morning if possible.
all right, Ms. Fisher, you're before the court this morning for one count of disorderly intoxication, and count two is trespassing, and the court does find probable cause. They are misdemeanor charges. A disorderly conduct is a second-degree misdemeanor. The trespassing is a first-degree misdemeanor. Does the state have an offer for Ms. Fisher?
Served on both counts, no return.
All right, Ms. Fisher, your attorney said that you wish to resolve the case today, all right?
Yes.
So if you wish to resolve the case, you will be sentenced to adjudication and time served, and you are going to be ordered not to return to this location. Do you understand that?
Yes.
Do you wish to accept that?
Yes.
Okay, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. And Ms. Fisher, do you understand everything that has been explained to you today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
And ma'am, do you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And have you ever been treated for mental or emotional illness?
No.
And do you understand, ma'am, that by taking a plea today, if you are not a U.S. citizen, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence on both counts, adjudication and time served. Good luck.
Thank you.
You're
Good
welcome.
luck, Felicia. Don't go back there.
All right. And Heather Roll.
She's here present, Judge, at Maine.
All right, good morning, Ms. Roll. These are traffic capious matters from 2013. What does Ms. Roll wish to do?
Judge, in speaking Ms. Roll, she wishes to resolve these matters today.
All right,
Offer be a withhold court cost.
Let me explain it to her.
okay.
Judge, she wishes to accept the state's offer.
All right, Ms. Roll, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Ms. Roll, you understand everything that has been explained to you today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
And ma'am, you do understand you have the right to go to trial on these matters, but by taking a plea today, you are giving up that right.
Okay.
Have you ever been treated for mental or emotional illness?
I'm disabled. I'm a former Marine, so I'm disabled now.
Oh,
So I get therapy.
Oh, this disability I understand, but have you ever been treated for mental or emotional illness? Okay? And do you understand, ma'am, that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right. Ms. Roll, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. And your sentence, ma'am, is a withhold adjudication and court costs. Okay, did you say that you were a former Marine?
Yes.
All right, well, we thank you for your service and, good luck, okay? All right. Eva Charles, is that a medical
I
loan?
believe that she is a
Recent?
medical loan, Your Honor.
Okay. All right, Wendy Amparo.
Here
Am-
North Broward.
What did you say? You said,
I said, here I am.
oh, okay, all
And there
right.
she is.
Sorry.
No, that's okay.
Sounds bad. I'm so sorry.
All right, so you are before the court today, ma'am. You've charged one as a traffic KPS. Looks like you, you have a traffic KPS on a driving while, driving with license suspended. And this KPS was issued April 16th of 2019. But then you also have two counts, two felony KPS charges. Those are no bond holds, that was signed by Judge Yuson. And so you have to go before Judge Yuson. You actually have a court date tomorrow before him. All right? So the court finds probable cause and you'll see your felony division judge tomorrow. Good luck.
Thank you very much. You have a nice day.
You too.
Good luck, Wendy.
Jessica Hernandez. All right, Ms. Hernandez, bond was posted. Is she there? Or is she bonded out? Well, it doesn't look like anyone is at, Paul Ryan. Her bond has been posted and the court finds probable cause. Selena Mays.
These are court room 6870,
Well, Your Honor?
Yes.
And then I would ask if you could ask the clerk to cancel the status set for tomorrow so we can actually have her here in court tomorrow.
Okay, all right, can we do that? Because this was a reset from yesterday as well. Okay. And then Jacqueline Beebe,
She's in courtroom 77B.
and then it must be
Same
the same
request.
thing, because there was a medical reset yesterday, so we cancel the status on Beebe, so she'll be here tomorrow, okay? Michael Hurd,
He's approaching, Judge, he's here at Maine. Come on up, sir.
all right, Mr. Hurd, you're before the court this morning. Charge one is battery causing bodily harm. Number two is felony battery. Number three is resisting officer without violence. The court does find probable cause. And I'll hear from the parties as to bond.
Your Honor, I'm going to be requesting $7,500 bond on one, $15,000 bond on two, no victim contact, pretrial release of the GPS monitor. And this is really based on the facts. It's not based on his history. He has an old felony theft out of Missouri. But frankly, I think the level of violence alleged in this case greatly outweighs any mitigating factors regarding a lack of history. I mean, the allegations are that he was attacking his wife, kicking her, punching her while she's on the ground. Who knows how far it would have gotten if the other victim didn't pull him off of her. And what happened in response to that is Mr. Hurd beat him so badly that both of his eyes were swollen shut when fire rescue got there, and he had disfigurement to his entire face. This attack was also done in the presence of their 5-year-old daughter, to where she ran over to the second victim, advising him that daddy is hitting mommy.
Okay.
Judge, in speaking with Mr. Hurd, I try to explain to him the process as far as magistrate. We're not here to, at this time, to contest the allegations. It's a non-adversarial hearing. But Mr. Hurd wanted me to advise you that he's definitely denying these allegations. He's looking forward to his day in court. Having said that, first, as far as prior that the state mentioned, my understanding, it was like over 20 plus years ago, and it wasn't a felony. I believe it was downpiled to a misdemeanor. So all he has in his record is basically, as far as a violent offense or anything like that, is what's here before the court. Judge, he's been residing in South Florida now for 20 years. He's 44 years old. He works for a company called Blattner Energy, where they build wind turbines. Right now, he's been off work there, however, for the past 2 months, he's getting paid. My understanding, Judge, is where this alleged incident arose, and I believe, hold on. My understanding, Judge, I believe it's the neighbor. They live at a duplex. They've been living there for the past 15 years, and he pays rent in the amount of about $1,000 per month. This is what's the problem. Unfortunately, when he was arrested, he didn't have an opportunity to have his phone with him. So he has no one to contact, Judge, no one to help post his bond, no one to inform that he's currently here. And he's right now not in a position to go into his own property and self-bond. So unfortunately, he's going to be stuck here with us. So, Judge, I'm asking, because of his ties to the community and his lack of criminal priors, Judge, I'm asking if the court would consider releasing Mr. Hurd on pretrial release. And also, I'm going to ask the court to sign and photograph the injuries that Mr. Hurd sustained as well.
And, Your Honor, I confirm with pretrial, on April 28th of 1997, he was found guilty of felony-level stealing in the state of Missouri.
All right, so at this time, based on what the court has heard this morning, the probable cause affidavit that has been reviewed, I am going to impose a $5,000 bond on count 1, 10,000 on count 2, no 10,000 on 2, no victim contact, and no possession of any weapons or firearms.
Yes, Judge.
Okay. Angelo Adams,
He's in North Broward, Judge.
all right, Mr. Adams, you're before the court this morning. Charge 1 is touch or strike battery domestic. Number 2 is resisting officer without violence. And number 3 is tampering in a misdemeanor proceeding. The court does find probable cause. And I will hear from your attorneys as to bond.
Your Honor, Mr. Adams was arrested for a battery against the same alleged victim in 2017. The charge was dropped. In light of that and these allegations, I would be requesting a $2,000 bond on count 1, $1,500 bond on count 3 in order of no victim contact.
I did speak with Mr. Adams' mother earlier this morning. I would ask the court to leave those bonds as requested by the state in place at this point.
All right, at this time, the court finding probable cause, $2,000 on count 1, 1,500 on count 3. Sir, no victim contact. What that means is no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am.
All right, good luck. Raymond Copeland,
He's here present, Judge, at me.
All right, Mr. Copeland, you are before the court on one charge of battery on a person 65 years or older. And the court does find probable cause. Does anyone wish to be heard?
Your Honor, I'd be requesting a $5,000 bond, no victim contact. This is based not only on the allegations. I would also note in 2016, Mr. Copeland was arrested for domestic violence battery against a Nicole Diaz, who was referenced in the report. The charge was dropped.
Okay.
Judge, under the circumstances, that's reasonable. That's what the,
$5,000, no victim contact.
thank you, Judge.
Richard Camaro.
He's approaching, Judge. Come on up, sir.
All right, sir, you're before the court this morning for one count of aggravated assault with a deadly weapon. So the court finds probable cause. And does anyone wish to be heard?
Yes, Your Honor, one moment, please. Your Honor, I'm going to be requesting a $10,000 bond and no victim contact. In addition to the high level of violence in this matter, I would note that Mr. Ekmero was placed on probation on June 11th of this year for 1 year by Judge Levy for DUI. In 2016, he was arrested for battery against a different alleged victim. That was dropped. 2016, theft and resisting a merchant. 2007, grand theft.
Okay,
Judge, what the state is requesting, Mr. Ekmero will not be able to afford. He's 31 years old, been living here for the past 25 years. He gets disability. He gets approximately $433 per month. Now, I did advise him because of the domestic situation, the court's going to impose no contact, so he will not be having any future contact with his brother until until another court changes that order. My understanding, Judge, and speaking to him, I do not believe from what Mr. Ekmero advised me that his brother wants to pursue this. But having said that, Judge, he will be living separate and apart. He'll be living with his father. Now, his father is on Social Security and he lives in Hollywood, so he has limited funds as well. He believes that maybe using the services of bondman, his father can afford a $2,500 bond. So that is why we're asking for a $2,500 bond on Mr. Ekmero's behalf.
all right, at this time, the court imposes a $5,000 bond, no victim contact, until further order of the court. Okay? Joshua Windheim.
He's approaching, Judge. He's here.
All right, sir, you are before the court this morning for one count of aggravated stalking after injunction. And the court does find probable cause. And I'll hear from the parties as to bond.
One moment, Judge.
Was Mr. Windheim brought from another
Yes, Judge,
county?
he was indicted from, I believe, Lake County.
Your,
Yes.
Your Honor, the state is going to be seeking a $20,000 bond, pretrial release of the GPS monitor level 2, no victim contact. And I do recognize he lives out of the Tri-County area, Your Honor, but I have a great concern about him continuing to have contact with this victim and disobeying not only the injunction that was previously ordered, but the anticipated no contact order that Your Honor will be issuing today. As you can see, Your Honor, at the time of this incident, there was an injunction in place that the victim sought after he was arrested for committing a domestic violence by strangulation against her. I would also note, since this incident, he was convicted of that strangulation and placed on 2 years probation in Lake County, July 11th of this year. He also has a previous arrest out of the state of North Carolina for violating a domestic violence injunction. That was in 2016. It does appear that the charge was dropped. In the state of New York, in 2003, he was arrested for harassment and endangering the welfare of a child. I have no disposition on those charges. One moment. He's also been convicted in the state of Florida, 2015, out of St. Cloud, violating an injunction. So there is really no reason to have much confidence that Mr. Winheim, without a proper bond and release conditions, will obey any judge's order to not have contact with this victim.
Okay.
Judge, I'm going to be requesting $1,000 bond with no form of supervision, and I do understand that that's quite a bit different from what the state is recommending, but this is why. As I said, he was extradited from Lake County. He was actually picked up there. There was an outstanding case over there in that county. I believe it was a domestic situation in which this is the same victim. He was placed on 2 years probation for this domestic offense. So my understanding in speaking to him, that in order for him to have gotten that offer from the state up there, they've certainly contacted, I'm assuming, the victim, so the victim would advise or informed as far as what the state is offering, and he was placed on probation. So Judge, he has bigger things to worry about as far as, like, if he violates that probation in any way, there's going to be a no bond hold placed on him. So Judge, that's why I'm asking for $1,000 bond, because there's a built-in mechanism. He will be supervised. Now, he's living in Lake County. He works at a place called Las Palmas, where he's a bartender, where he makes about $300 a week. He lives there and he rents a room, and his monthly rent is approximately $800 per month. The only person that's going to be able to afford help or in a position to post his monetary bond is his mother, and she's on a fixed income. She gets Social Security. He believes at most that maybe she can come up with $100 using the services of a bondsman. So that is why I'm requesting $1,000. Now, he will be coming back to court to account for these, but what resides is in Lake County, Judge. That's where his probation is. That's where he has to report to his probation officer.
When was he placed on probation?
5 days ago, Your Honor. And frankly,
5 days ago?
5 days ago, and Your Honor, there's no reason to believe that the prospect of getting arrested for violating his probation is a proper deterrent, considering on at least 2 occasions he knew that if he contacted this woman and violated a court's order, he faced arrest. He still faced the same arrest he'd face for a violation of probation. That wasn't enough to stop him.
All right, at this time, I am imposing a $10,000 bond. He's also going to be on pretrial, no victim contact, but that order was already in place, so, I just have to repeat it again, no victim contact. That means no phone calls, no text messages, no social media, no third-party contact, okay?
And that's regular pretrial, correct, Judge?
Right, because he lives in
He lives in
Lake County.
correct? Thank you.
Yes, yes. All right. Felony, Jaquise Dowling,
Conti, Your Honor.
okay? Mr. Dowling is before the court on 1 count of felony battery. Oh, it's
It's a change of charge,
a
Your Honor.
change of charge, a down file?
Yes, bond was originally set at $2,500 though, and I would ask that bond be kept in place with an order of no victim contact.
All right. So, Mr. Dowling, just so you understand, when you were arrested, you came before the court on a aggravated battery with a deadly weapon, and it's now been changed to a felony battery. So, the court does find probable cause for the felony battery, and your bond was $2,500. That's going to remain, and the no victim contact order is still in place.
And
Okay?
he'll be seeing Judge Allspector Thursday morning for his arraignment.
And you have court on Thursday before your
Okay.
division judge.
I was going to ask the court to reduce the bond in light of the fact that the charge has been downfiled, but if he's going in front of Judge Allspector on Thursday,
Okay.
that's something can be addressed there. All right, good luck to you, sir.
Mark Mazzarelli.
He's here, President Judge, I mean.
All right, Mr. Mazzarelli is before the court on a loitering or prowling charge. The court finds probable cause.
Judge, it's me, Mr. Mazzarelli. He would like to resolve the second-degree misdemeanor.
All right, does the state have an offer for Mr. Mazzarelli?
Would be adjudication, time served, no return. No,
Does he have priors?
I'd have to check. Nancy, well, I need 1 moment, Your Honor.
No, never mind.
He wishes to accept the state's offer,
Okay.
Judge.
All right, sir, please raise your right hand. Do you swear affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. Mr. Mazzarelli, do you understand the offer that has been presented to you?
Yes.
Is anyone forcing you to resolve your case?
Not really, no.
Well, it can't, is anyone forcing you to resolve your case?
No.
All right. Do you need any more time to speak with your attorney?
No.
And sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
And have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Mazzarelli?
No contest?
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck. Nicholas Acosta.
He's approaching, Judge. He's here, I mean.
Mr. Acosta, you're before the court on 3 traffic capias charges. This is a capias from 2017. You did not appear for arraignment. These are all driving unlicensed suspended, operating without a valid license, and failure to register vehicle. So that's why you're here today. So what does Mr. Acosta wish to do?
Judge, he wishes to resolve this matter.
All right. Okay.
The offer would be adjudication, time served on all counts. From what I can tell, this would be a second DWLS within a 5-year period.
Okay.
And, Your Honor, while Mr. Romero is speaking, if we could possibly call a case at a turn on page
He wishes to
21.
accept the state's offer, Judge.
Okay. All right, Mr. Acosta, do you understand, I believe your attorney has explained to you that, did you say this is a second within
This would be a second within 5.
5? And so you understand the repercussions of having a third one?
Yes, he just told me.
Okay, all right. And knowing that you still wish to resolve your case today?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. Mr. Acosta, do you understand everything that has been explained to you today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
And have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Acosta? Guilty or no contest?
No context.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence on all 3 counts is is adjudication and time served. Good luck, sir. All right. All right, and then on page 21, Carrick Haddon. Good morning. 21. Carrick Haddon. So Mr. Haddon is before the court this morning. Charge number 1 is intimidation, right, send, or threaten to kill or injure. And then 2 is a felony violation of probation with a no bond hold. And Mr. Haddon does have court tomorrow before his division judge.
And, Your Honor, before the court makes a determination, I asked Deputy McHenry to come to court this morning. He authored the probable cause affidavit to testify under oath to provide a little more information about the specific threats that were made.
Okay. All right, Deputy, is that correct?
Yes, ma'am.
Okay, please raise your right hand. Do you swear or affirm to tell the truth?
I do.
You can put your hand down and please state your name for the record.
Roderick McHenry.
Thank you. You can go ahead, state.
Thank you, Your Honor. Deputy McHenry, who are you employed by and in what capacity?
Broward Sheriff's Office. I'm a detective in the Threat Management Unit.
Oh, you're a detective?
Yes.
Okay, I apologize.
No, that's fine. I'm still a deputy.
Detective McHenry, you investigated a complaint made by Carla Haddon about her brother Carrick Haddon sending her intimidating, threatening messages over social media?
Yes.
Excuse me, could you please inform the court what your investigation involved in this matter?
After making contact with Miss Haddon, she advised that her brother had showed up because she works at the same building that I work at, the public safety building, in a different department. That he had showed up unannounced to her job. He had been sending threatening messages on Facebook, directed specifically at her. And when she went out to the lobby, because his last message to her was outside in the lobby, and she went out there and noticed that he was actually there, so she ran back in her office, very fearful, and my department was notified, came down and spoke to her. She showed me the messages, showed me a picture of her brother, went out to the lobby, confirmed that that's who it was. I spoke with him briefly. He agreed to do an interview, in which he also admitted that he did send those messages to his sister. Some of the messages being, you're going to be the next one on a rest in peace shirt, and you're not going to know where it's coming from. Another message was, B word, I'll kill you and who you came with. And another one was, F you, B word, I'm going to F you and your car up again and put you back in the hospital, and this time have you on your dying bed. And he was referring to an incident that happened back in May where he threw bricks through a window and injured her, and he was arrested for that back then. And he was currently on probation at this time because of that.
Okay.
Well, Your Honor, nothing further from the state, so I'll wait till the court makes a probable cause determination.
Okay, so based on what the court has heard, the testimony from Detective McHenry, the court does find the probable cause.
May I approach Your Honor?
Sure.
Your Honor, and I've shown that to Mr. Reedy, and I'm providing the court with a copy of the probable cause affidavit from the batteries on probation for. You can see the allegations that Detective McHenry already described. The same victim in this case was the victim in that case. I've also provided the court with a copy of the order of Judge McHugh's probation, which clearly lists that no contact with the victim is a condition of his probation. Your Honor, in addition to that, in late June of this year, the victim sought and obtained an injunction order of protection that Judge Michael Kaplan granted, putting in place till June of 2022. Your Honor, the victim in this case, my understanding, is in great fear of Mr. Haddon, and I do believe an appropriate bond and release conditions are necessary to ensure her safety. I am going to be requesting a $20,000 bond pretrial release with a GPS monitor, no victim contact.
Okay,
Judge, as the court is quite aware, most of the time there's always two sides to every story. My understanding, Judge, is the location where I believe Mr. Haddon had contact with this individual that's here before us. So I believe it's a public safety building of some kind where law enforcement is there. He is under the impression, Mr. Haddon, that he wanted to try and obtain a restraining order on his sister. He felt threatened. The victim, from what he advised me, actually threatened him, said she was going to run him over. So he knew that there was law enforcement in that building, and that's why he went there to try and seek a restraining order. Having said that, Judge, I know you'll have his day in court, but he is also being held no bond on count 2 for VOP. Right now, financially, though, he's not working. He's basically homeless. He's financially indigent. So I'm asking you to take all that into consideration, determining reasonable release conditions for Mr. Haddon.
And Your Honor,
well,
frankly,
here we are before the court when there is already an injunction in place. He's on probation for for similar acts. I don't know how Mr. Haddon can say that he didn't, well, not that he didn't know, but
Yeah.
he goes to get supposedly a restraining order, but then the allegations is that he was outside texting his sister.
And Your Honor, if I could just, and I just want to bring to the court's attention one other thing. Mr. Haddon applied for an injunction against a different individual in 2015, so he knows what process to go through. To claim that he actually went to the public safety building to seek an injunction, I don't believe is genuine.
All right, so there's already a no contact order in place through the injunction that has been violated. I am imposing a $20,000 bond, and that's going to include a pretrial with an ankle monitor. Okay? And need I say again, no victim contact. Mr. Haddon, I'm asking you to stop talking and listen. No victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes.
Okay.
Yes.
All right, Matthew Perry? Mr. Perry is before the court on a trespass charge. The court finds probable cause.
Judge, it's being Mr. Perry. He wishes to contest this allegation. I believe the trespass location is at a shopping center. I did advise during the pendency of this case. He's going to have to stay away from there until he has his day in court, until another judge modifies that. But right now, Judge, he's currently looking for employment. He's basically homeless. He has no one that's going to be able to help post his monetary bond. He does have prior contact with the criminal justice system, but I believe it was back in 2018. He's been living in our community for over 20 plus years. He will be coming back to court. So I'm asking if the court will consider releasing him on ROR on his trespass offense or the alternative on pretrial release.
Well, the police report here says that January 7th, 2018, Mr. Perry was arrested for trespassing at the Big Lots. This location is the Coconut Creek Plaza, so it's in the same place. And today he was observed again there, and that there has been several trespass warnings that has been issued. So, I'm not saying for him not to have his day in court. That just does not give me confidence that Mr. Perry is following orders. So at this time, I am going to leave the $25 bond in place, and I am going to order that you do not return to the Coconut Creek Plaza from which you've been trespassed several times.
Judge, being Mr. Perry, he wishes to address the court. I did advise him not to speak about the facts of the case. Judge.
No, okay.
Okay, I don't see a probable cause for the arrest. The address is completely different from the first address.
All right,
They didn't put that in their
okay,
report.
Mr. Perry, you can have
And I'd
that
like to be
Have that
And I'd like to
conversation
be
with your
released on
attorney.
recognizance.
That will be denied. Have that conversation with your attorney. Elijah Saki.
There's really no probable cause for the
If you keep talking, I'll raise the bond. Mr. Saki, you're before the court on 3 misdemeanor capias charges, and the court finds probable cause. It looks like these are from last year, a year ago. The capiases were issued for not showing up to arraignment, operating without a valid license, failure to register vehicle, unlawful use of false identification. Those were the charges that you were supposed to appear in court on. So you do have bond set, and you do have a status tomorrow before your division judge. So,
Mr. Saki wishes to resolve this matter today.
okay. Does the state have an offer for him?
Be time served.
Okay.
He wishes to accept the state's offer, Judge.
All right, sir, please raise your right hand. Do you swear affirm to tell the truth?
Yes, ma'am.
Okay, sir, put your hand down. You can put your hand down. Do you understand everything that has been explained to you today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And sir, do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter? Guilty or no contest?
No contact.
I accept your no contest plea. I find that it's freely and voluntarily given, and you've been sentenced to adjudication and time served on all counts. Good luck, sir. Roger Linenger.
He's approaching, Judge. He's here at Maine. Come on up, sir.
All right, Mr. Linenger is before the court. Charge 1 is obstructing the highway, and number 2 is a municipal ordinance, it's a county violation. So, the court finds probable cause. What does Mr. Linenger want to do today?
He wishes to resolve the matter, Judge.
All right. All right, Mr. Linenger, you'll be sentenced to adjudication and time served if you wish to resolve the case. Do you wish to accept that, sir?
He wishes to accept the offer, Judge.
All right, sir, please raise your right hand. Mr. Linenger, raise your right hand. Yeah. Do you swear affirm to tell the truth?
Pardon me?
Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. You can put your hand down. Can Mr. Linenger hear me?
He's a little bit hard of hearing, Judge.
I suspect that. All right. How are we gonna do this? All right, Mr. Lineger, if you wish to do you understand everything that has been said here today?
Do you understand everything that has been said here today? Yes, ma'am.
And is anyone forcing you to resolve your case?
No, ma'am.
And do you need any more time to speak with your attorney?
No.
Okay. And do you understand that you can go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Were you arrested by yourself?
I guess so. Not a guess. Do you understand that, sir? Okay, I understand her. Can you repeat repeat the question one more time?
Sir, do you understand that if you are not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Let the judge know if you understand, sir.
Yes, ma'am.
Okay. What plea do you wish to enter? Guilty or no contest?
No contest?
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir. All right, next we have Kendall Bolden.
Mr. Bolden is in the North Broward Detention Facility, Your Honor. He would like to resolve this matter this morning.
Okay.
Yes, ma'am.
All right, Mr. Bolden has a misdemeanor capias. Mr. Bolden did not show up for arraignment on July 2nd of 2019. That's why you're here. And you wish to resolve your case today, is that correct?
Yes. Yes, ma'am.
What's the offer?
It's, the documented offer from the state is withhold court cost, no return to 101 Northeast Avenue in Fort Lauderdale.
Did you hear that, sir? That you cannot go back to that address? You have to speak and you have to answer yes or no, okay?
Yes. Yeah, I was told that.
All right, sir. You said withholding court costs?
Yes.
Okay. All right, sir, please raise your right hand. You swear or affirm to tell the truth?
Yes.
You can put your hand down. Mr. Bolden, do you understand the offer that has been extended to you?
Yes.
Has anyone made you any other promise?
No.
And do you need any more time to speak with your attorney?
No.
Do you understand, sir, that you can go to trial, but by taking a plea today, you are giving up the right to go to trial?
Yeah.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Okay.
Do you understand?
Yeah.
Okay.
I understand.
What plea do you wish to enter, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. You've been sentenced to withhold adjudication and court costs, and you're ordered not to return to that location. Good luck, sir.
Okay.
All right, take care, Kendall.
All right.
Stay away from that place.
All right. Edward Sikorsky.
He's approaching, Judge, you hear me?
All right, Mr. Sikorsky is before the court for contempt of court. And there's a misdemeanor capias as well. It looks like, did he go before the judge yesterday on the contempt? Okay.
They did an order giving him 10 days in Broward County.
Okay. Then I don't. Well, he also has a misdemeanor capias. And you do have court tomorrow before your division judge. But if he's already been sentenced on the contempt of court, what are we doing with that? It has a no bond hold, but he's been sentenced.
He's on here on count two.
If you want to resolve,
Is he only here on count two? Oh,
if you want to resolve the offer, be a withhold court cost.
okay, all right.
Judge, you said he was sentenced on the count one on the contempt. What was he sentenced to?
10 days.
Oh,
10 days. So the offer on the capias is what? Withholding court costs?
Yes, ma'am.
If he
Let me
wishes,
ask him, Judge.
okay. Sheila, just so your records reflect that he's sentenced to the 10 days. Only because the paperwork that I have says no bond hold, but I know that this doesn't matter as long as your records reflect. Okay. Okay, okay.
Judge, at this time, he just wants to know more information regarding the 2012. He's set to go to court tomorrow, so he's going to ask his public defender then.
Okay, no problem. So
Thank
there's
you, Judge.
bond in place. Jacqueline O'Neill, it's supposed to be O'Neill or O'Neill?
He's approaching, Judge.
Sir, how do you say your last name?
O'Neill.
O'Neill? Okay. You are before the court on a trespassing charge, and the court finds probable cause.
Judge, speaking Mr. O'Neill, he wants to go to court on this case. We're going to be asking for an ROR. Right now, he's going to school. He goes to Broward College, studying business. He's been here his whole life, 23. He lives with his mom. So we're asking the court will consider an ROR on this trespass offense.
I'm going to deny that. The court does have concerns based on what's in the probable cause affidavit. I'm not sure what's going on, but he was in the store for over an hour eating. They asked him to leave. The officers came, asked him to leave. He left the store. He went back in the store. I don't understand what's going on. So I'm not going to ROR him at this time. I will release him to pretrial supervision. If
That's fine, Judge. This is a map to pretrial, and you're going to have to report there today. It will be released today. You see here's the main judge, just walk across the street, and that's where you go to, okay? And they'll explain to you what a pretrial is all about, okay?
Mr. O'Neill, you must report to the pretrial office and follow whatever orders that they'll give you when you report. If you don't show up, sir, a warrant will be issued for your arrest. Do you understand that? Okay, good luck.
Good luck, sir.
Anthony Canino?
He's approaching, Judge. He's here at me.
Mr. Canino, you're before the court for a petty theft charge, and the court finds probable cause.
Judge, speaking of Mr. Canino, he wishes to resolve this matter today.
Are all the items returned?
Does not appear so, so I have no offer at this time.
And that's what I was afraid of. Mr. Canino did advise me was, I believe the store was Dollar General, the dollar store. Having said that, Judge, he's homeless. He has no one that posts his monetary bond. He does have contact with the system, but he believes it's been about 10 years. So I'm asking if the court would consider an ROR on his behalf.
I'll release him to standard. Does he have priors?
He does, Your Honor, and to say, his hasn't been in trouble in 10 years, technically that's true, but that's also because 65 months out of those 10 years, he was in state prison as a habitual offender. Extortion, dealing in stolen property, attempted burglary of a dwelling, burglaries, conveyances.
All right, I'll release Mr. Canino to pretrial supervision. Sir, you need to make sure you show up at the pretrial office, sign up, and if you don't, a warrant will be issued for your arrest. Daryl Francois.
Francois, come on up, please. He's approaching, Judge. You hear me?
Mr. Francois, you have 3 misdemeanor cases. You did not show up for your court hearing in February of this year. And the charges are possession of cannabis and petty theft. So bonds are in place on, each of those cases, $100, $250 on 2 and 3, and you do have court tomorrow before your division judge. And based on the nature of the charges, I'm gonna leave the bond in place, and you'll see your division judge tomorrow. Carl August,
No problem, Your Honor.
okay? Mr. August is before the court on a trespassing charge. The court does find probable cause.
I believe Mr. August may wish to resolve this matter this morning,
Okay.
Your Honor.
All right. State you have an offer.
I'm sorry, I have the wrong number. One moment, Your Honor.
Sure.
Your Honor, I don't have an offer. I don't know, maybe, frankly, if Judge Lerner Wren might be a good option. He's out right now on an ROR. The state still, frankly, the state hasn't filed an information, but he was arrested in April this year for arson that was committed at the Northgate Neighborhood Park.
Is that matter before Judge Lerner Wren?
It's felony, and it
Oh,
hasn't
it's
been
a felony
filed.
matter.
The allegation is he started,
I think I remember this. Wait. All right, so at this time, I'm gonna leave the bond in place. Is he represented by the Public Defender's Office, Mr. Reedy? Okay, and
he is on the arson case.
I'll sign a transfer order to Judge Lerner Wren's division on this matter. Okay? All right, good luck, sir. Pedro Cabrera.
I'm sorry, I've got the wrong number.
Mr. Cabrera is approaching Judge. He's on me.
You dial 5870.
All right, Mr. Cabrera, you're before the court for add charges. Charge number 14, burglary, unoccupied dwelling, unarmed. 15 is grand theft, and 16 is grand theft auto.
Your Honor,
The court does find probable cause.
Your Honor, I'm going to be requesting a $20,000 bond, considering this was someone's home. The value of the property that was stolen from the home, $16,000 in cash and a $34,000 Mercedes, noting that he's currently being held no bond on the following charges: 4 separate burglaries for violating pretrial, 5 separate grand theft autos for violating pretrial, and a bond surrender on a burglary. She was supposed to give me the courtroom phone number.
All right, the defense wish to be heard?
He's been in custody since, I believe, last year, and no bond hold, so nothing cash from the defense. Now, he is represented by the Public Defender's Office on his other matters, so I'm gonna try and email his attorney and let him know that he's here on 3 ad charges.
All right, so 20,000 on 14, and then the other standard bonds remain. And if Mr. Cabrera bonds out, no return to this location.
Sure, no return.
Okay. Ricardo da Silva.
please. He's approaching, Judge.
No, because if that's our courtroom number, it's not gonna show up on here.
All right, Mr. Da Silva, you are before the court. Charge 1 is possession of drug paraphernalia. 2 and 3 are felony violation of probation. Those both have no bond holds, and you do have court tomorrow before your division judge. The court finds probable cause. Your bond on count 1 is $100.
It's complete. It said alien.
Jason Palmer,
Mr. Palmer, come on up, please.
Mr. Palmer is before the court. Charge 1, possession of methamphetamine. Number 2 is possession of controlled substance without a prescription. And number 3 is possession of clonazepam. And the court does find probable cause.
Judge, unfortunately, when Mr. Palmer was brought here, he was brought with his phone, but his phone unfortunately is dead, has no battery. And as you know, not gonna allow him to charge his phone, so he has no one to contact to help post his monetary bond. Now, he's 33 years old, been living in our community for about 2 years. He's employed. He works at a company called NCR. It's a call center where he does customer service. He lives in Fort Lauderdale, where he's been renting a room. He's been there for about 6 months, and his monthly rent is $450. So I'm asking on these non-violent offenses if the court would consider releasing Mr. Palmer on pretrial release.
Your Honor, he was just placed on pretrial earlier this year on a theft that he resolved mid-June of this year. In that matter, he stole an individual's phone. The individual was chasing him to recover the phone, fell and fractured his kneecap, and had to miss work.
All right, at this time, I will release Mr. Palmer to pretrial supervision. That's going to include random drug testing. Okay? Mr. Palmer, you need to make sure, I think you've been through it before, you need to show up. You need to sign up. If you don't, a warrant will be issued for your arrest, okay? Shanard Neely,
Mr. Neely's approaching, Judge.
all right, Mr. Neely's before the court. Charge 1 is disorderly conduct. Number 2 is resisting officer with violence. Number 3 is trespassing, and the court finds probable cause. All right, does anyone wish to be heard in regards to the bond?
Requesting a $2,000 bond on the resisting with violence, Your Honor. He was just arrested late May of this year for trespassing at the Broward Health Medical Center. Really, the behavior in this matter is really outrageous, considering this is an emergency room where people require health treatment, and how he was behaving at that time in the emergency room, simply because the hospital needed to discharge him. He also has a trespass April of this year, and that is at a different location. Moment. Trespass last year, failure to register as a career offender. 2015, 2-year state prison as a habitual offender. It's been to battery 09, resisting without violence 09. It's been to prison multiple times, once in 97, 10 years as a habitual offender for grand theft auto, assault on a law enforcement officer, aggravated fleeing and eluding, 77 months from a 1996 robbery with a firearm or deadly weapon.
Okay,
Judge, $2,000 is something Mr. Neely does not have. He's looking for employment. He's been here his whole life, but he's homeless. So no one's gonna be able to post his bond. So we're asking for pretrial release.
all right, I'm going to deny that at this time. Mr. Neely, if you need some place to sleep, you need to seek out other services. You know, the allegations he's sleeping, he's telling the cops to leave him alone, and then that just escalated into something bigger. So the bond is $2,000, and at this time, no return, okay, to that hospital. Chesnell Florimon,
He's approaching Judge Jermaine.
all right, sir, you are before the court. Charge 1 is possession of heroin. 2, 3, 4, and 5 are felony KPS matters with no bond holds and are not for magistrate. 6 and 7 are a violation of probation, also with no bond hold. Number 8 is a felony KPS. Number 9 is a misdemeanor KPS. The court finds probable cause. The bond on count 1 is $1,000. I'm leaving that in place, and you do have court before your felony division judge tomorrow at 8:30. Okay? Official coffee. Do we say it some other way, but it's spelled official coffee?
He's here, President Judge.
Okay,
All you can do is read what's in front of you.
that's all I'm doing. That's what it says. All right, Mr. Coffey is before the court on charge 1, fraud, possessing ID of another person without consent. Number 2 is traffic in counterfeit credit cards. And number 3 is possessing ID of another person without consent. So you have counts 1 and 3 are similar counts, and then count 2 is trafficking in counterfeit credit cards. The court does find probable cause.
Your Honor, it looks like he was just brought down. It looks like whenever he's done here, he's got a DOC
He's
hold.
been brought from Avon Park or something.
Yeah,
Okay.
it looks like he'll see Judge Siegel next Monday.
Okay, all right, so we'll leave the bonds in place and you'll see Judge Siegel. Roland Predilos,
Mr. President, come on up, please.
Mr. Predilos is before the court, charge 1, aggravated battery, number 2, assault, number 3, criminal mischief. And the court finds probable cause.
Your Honor, Mr. Perdilis' criminal history includes a 2013 resisting without violence, trespass 2010, theft 08, resisting without violence 08. But that being said, Your Honor, I'm going to be requesting a $10,000 bond on count 1, no victim contact, pretrial release of the GPS monitor. I am concerned, even if Mr. Perdilis assures the court that he would follow a no contact order, I have concerns not only that it won't be followed, and if it isn't followed, what could potentially happen, considering after the incident with the aggravated battery where he threw a large rock through this business's window where caused the victim to suffer lacerations from the broken glass, he advised an employee while law enforcement was listening that he would come by to pick up his refund check sometime this week, and when he gets there, he's going to cut the employee's throat and kill everyone inside the business.
Okay,
Judge, Mr. Perdilis has been here his whole entire life right now. He's on disability and he's homeless. So I'm asking you to take that into account and determine reasonable release conditions.
all right. Based on the allegations, the probable cause affidavit, at this time, I am going to impose a $10,000 bond on count 1. The other standard bonds in place will remain. No victim contact and no return to this location. Do you understand that, sir? And sir, just so you understand that no victim contact means no phone calls, no text messaging, no social media, no third-party contact. Do you understand that, sir? Okay,
Is Your Honor not placing him on a monitor at this time?
no.
Okay.
Dylan Downer,
Like a loan, I think, Judge.
is that a medical loan?
It is.
Charles Thomas, all right, Mr. Thomas, you're before the court on a violation of probation, charge 1. And number 2 is an out-of-state felony hold. This is a hold out of the state of Georgia. Those are both no bond holds. As to the violation of probation matter, you will see your division judge tomorrow at 8:30. Michael Knowles, where's Mr. Knowles?
Mr. Knowles is here, Judge.
Okay. Mr. Knowles is before the court, false ID given to law enforcement. Number 2 is possession of drug paraphernalia. Number 3 is grand theft. Number 4 is a violation of parole. That has a no bond hold, so Mr. Knowles should be going before the parole board shortly. And then the bonds in place on 1 and 3 will remain, okay? Staffon Spencer.
Come on up.
Mr. Spencer is before the court on a grand theft charge, and the court finds probable cause. Does anyone wish to be heard as to bond?
Nothing at this time, Judge. I'm getting the phone number of his mother, and she will pay his bond.
Does he have any priors?
I'd have to check, Your Honor. I'm just showing that it looks like he does not have ties to the community while I'm looking up history. This happened, I guess, at the airport. And
Right, he was arrested in the airport.
I'm showing. Significant juvenile prior, Your Honor. Looks like, from what I could tell, attempted murder.
The allegations are that he took a watch as they were going through security from a bin. And when he was approached, somehow he said that he thought he had a watch like that or something. Is that the only one prior that he has?
That's all I see.
All right. Okay, so I'm gonna leave this $1,000 bond in place, okay?
Yeah.
Stanley Harris,
Mr. Harris, come on up.
Mr. Harris is before the court. Charge 1 is possession with intent to sell, manufacture, or deliver cannabis. Number 2 is possession of drug paraphernalia. And number 3, violation of felony probation. That has a no bond hold attached to it. The court does find probable cause, and the standard bond on 1 will remain. And he sees his felony judge tomorrow at 8:30. Terrence Thompson. Mr. Thompson bonded. The court finds probable cause. Yorick Scott. Ms. Still on medical loan. Marcus and Jenny.
Loan.
He's on loan, okay? And Gary Haberly, medical
I
loan,
would just ask if the court can make a probable cause
we did
determination.
yesterday.
Oh, did you? Okay,
Yes.
thank you, Judge.
And Brendan Jones,
On.
all right, Mr. Jones,
Good morning.
good morning, sir. These are change of charge.
It's a change of
It's-
charge where Judge Coleman previously,
It looks like that, well, I'll tell you, on my probable cause determination form, it says 1 and 2 are a violation of pretrial.
yeah, what happened was Judge Coleman signed the violation of pretrial warrant before the state filed the information.
Okay,
So when the change of charge capias was created, it automatically created it as no bond hold for magistrate. But I would be asking, Your Honor, based on the order, previous order that Judge Coleman signed, that these be kept in no bond.
okay. And Mr. Jones is raising his hand. Yes, sir.
Brendan, just remember, everything that you say has been taken down, so don't discuss the facts of your case, all right?
Wait, stop. Did you hear what your attorney just said?
Yes, ma'am.
Because you were talking while he was talking, so I don't know. Did you hear what he said?
I'm sorry.
What did he say?
He said something about this. I'm
Stop.
being recorded.
All
It
right.
could be used against me.
Okay, all right. So
Understand.
what is it that you are going to say, or you want to
You-
say?
Previously, you had reinstated my pretrial release, and I don't understand why was I picked back up.
I don't think I could have reinstated your pretrial.
Yes, I was out on pretrial release doing fine, and for some reason they picked me up with these warrants, and I was doing fine on my pretrial release. I don't understand why I'm in custody.
Well, you'll have to go before your division judge to have that conversation. Did
And
I
I'll try
put
and
him on
get you there as soon
pretrial?
as I can.
Is that what he's saying? I don't know.
I'm not sure, Your Honor. I mean,
Okay.
either way, Judge Murphy put him on pretrial.
Okay,
Judge Coleman obviously had an issue. There was a new arrest for resisting without violence. He is scheduled to have his arraignment before Judge Coleman next Tuesday morning.
all right. So, Mr. Jones, please have this conversation with your attorney, and then when you go to court, you'll speak with your division judge, okay? All right, good luck, and thank you, everyone. And I will
Judge.
see everyone. There's always one more. I'll see everyone this afternoon.